Hi, welcome back. In this section, we are discussing about rule against hearsay evidence. So that is one of the basic principle of Indian Evidence Act, that hearsay evidence is no evidence, but there are some exceptions to this. So that is what we are gonna discuss here. Hearsay evidence. Hearsay evidence, as such, is discussed in Section 60 of Indian Evidence Act 1872. The evidence given by a person who has heard the fact from another is called hearsay evidence. The person who gives hearsay evidence will not have a personal knowledge of the fact. Hearsay evidence comes indirectly through the knowledge of some other person. Not much value is attached to the hearsay evidence. The giver of hearsay evidence cannot be subjected to proper cross-examination. The witness may not be able to vouch to say the truth of his statement. The hearsay evidence, though not admissible, is subject to following exceptions. The first one is admission, second confession, third dying declaration, then the fourth one previous statement, the fifth opinion, the sixth entries in the book of accounts, and the seventh entries in public registers and records. So with respect to admission, any fact which is specifically admitted need not be proved. If there is any denial, it can be proved by hearsay evidence. Confession. All confession may, according to the procedure, be admissible in evidence. The person who recorded the confession is entitled to give evidence. Dying declaration. Dying declaration are also to be recorded by competent persons. Such persons are entitled to give evidence since the deceased declarant cannot be a witness. Now, previous statement. Any statement made by a person in a proceeding can be used by examining the person who recorded it. Now, opinion. Experts derive knowledge from various sources. The opinion of the experts is admissible in evidence. And the next one is entries in book of accounts. Entries made in any account books by any person can be proved by hearsay evidence. The next one is entries in public registers and records. Entries in any public register or record can be proved by a person who is in charge of that office. There are several reasons for the exclusion of hearsay evidence. According to Phipson, the reasons are the following. Here 4 reasons are given. The first one, there is no responsibility on the original declarant. Second, the original declarant has not made his statement on oath and is not subjected to cross-examination also. The third one, the opportunities for fraud are more in hearsay evidence. And the fourth, hearsay evidence will tend to encourage the substitution of weaker evidence for stronger evidence. Now, res gestae, the doctrine of res gestae is discussed with respect to Section 6 of Evidence Act 1872. It is necessary to consider a number of facts to decide the nature of the liability or right. Those facts may extend over a period of time. The relevancy of these facts forming part of the same transaction is called res gestae. Res gestae means matter connected with each other. All the facts of res gestae are relevant. The surrounding facts in any transaction usually from res gestae. It provides connecting links which render the existence or non-existence of a fact an issue. For example, in the commission of a crime, the motive, preparation, conduct, and so on are collateral facts which explain the relevancy. Section 6 of the Evidence Act deals with the relevancy of facts forming part of the same transaction and is as follows. Facts which, though not an issue, are so connected with a fact in issue as to form part of the same transaction are relevant whether they occur at the same time and place or at a different time and place. For example, 1. A is accused of murder of B by beating him. Whatever was said or done by A or B or by bystanders at the beating, or so shortly before or after it as to form part of the transaction is a relevant fact. The second one, A is accused of waging war against the government of India by taking part in an armed insurrection in which property is destroyed, troops are attacked and goals are broken open. The occurrence of these facts is relevant as forming part of the general transaction, though A may not have been present at all of them. Third, the question is whether certain goods ordered from B were delivered to A. The goods were delivered to several intermediate persons successively. Each delivery is a relevant fact. Some facts, though not an issue, are connected in such a way that it forms the transaction. Such facts are known as res gestae. The res gestae must be closely connected by time, place, purpose, design, and so on. One of the essential conditions of res gestae is that statement must relate to the main event or explain the main event. It must be a statement by a person who has either participated in or witnessed the act. All acts which are part of one transaction or acts constituting a series or showing continuing facts would be admissible as res gestae. And we have two important case laws here. Actually, four important case laws. That is, first one, Pollachan versus State of Kerala 1993. Pollachan versus State of Kerala 1993. The statement made either during or immediately before or after the occurrence is admissible in evidence as relevant fact forming part of the same transaction. However, the statement should have been made contemporaneously with the act. So that was held in Pollachan versus State of Kerala, where the court held the statement made either during or immediately before or after the occurrence is admissible in evidence as relevant fact forming part of the same transaction. However, the statement should have been made contemporaneously with the act. Now the next case law is R versus Foster 1834, which is one of the very important case law. R versus Foster. The accused was charged with manslaughter of B by driving a car over him. A pedestrian, was called as witness for the prosecution. A stated that he saw the vehicle at a very high speed but did not see the accident. A also stated that he heard the victim's cry immediately after the incident and went to him. B told A that the vehicle had knocked him down. The statement was held as admissible. Now another very important case law, that is R versus Christie. That is 1914 case, R versus Christie. Here the court held all statements which were made after the act was completed were inadmissible. That is, all statements which were made after the act was completed were inadmissible. The statement to be relevant as part of the same transaction must fulfill the following conditions. 1. The statement must be a statement of fact and not of opinion. 2. The statement must have been made either by a participant in the transaction or by a person who himself witnessed the transaction. So that was held in R versus Christie. Now another important case law, that is Nasiruddin versus Emperor 1943. Nasiruddin versus Emperor 1943. Here Fakirai was murdered in the bazaar. Fakirai was murdered in the bazaar. One Aishan Bibi appeared as a witness at the trial. He stated that when she reached the spot, she heard people saying that Raja Nasirullah and Jagari had committed the murder. But it was not stated that person who made the statement were present at the spot at the time of the commission of the crime. Hence, the evidence was not held not admissible. So, a person A was murdered in the bazaar, and the witness B, when she reached the spot, she heard another two people, C and D, saying that the accused A1 and A2 murdered the person A in the bazaar. But they did not. It was not mentioned that whether C and D was present at the spot at the time of commission or not. So, for this reason, the court did not admit the statement of B, who heard C and D say that A1 and A2 are the accused, or they are the persons who committed the murder. Now, the question was so that is with Nasiruddin versus Emperor 1943. The question as to whether a fact forms part of the same transaction as the fact in issue depends on various factors. The following are the tests usually applied. The first one, if the fact in issue and the fact of which evidence is sought to be given stands in relationship of cause and effect, then the fact is said to form the part of the same transaction. However, this is not a sound test, since every event would then become the effect of innumerable causes. And the second test is if the fact in issue and res gestae is connected by proximity of time and place, then the fact is said to form part of the same transaction. So the two tests is, One is the relationship of cause and effect, and one is the proximity of time and place. The test with respect to relationship of cause and effect is not an effective one, because it might end with a every event would become in the effect of innumerable causes. That is why we always prefer more towards the proximity of time and place. Now, res gestae versus narration. Res gestae should be distinguished from narration after the occurrence of the event. The parties or bystanders may often discuss the incident. The part event will be narrated by somebody for the benefit of others who gather these. The statement being narrative is not admitted as evidence, becomes hearsay. Now here we have a case law, that is Dharawat Kishan versus State. Dharawat Kishan versus State, 1993. Murder of the first wife by her husband through strangulation. The second wife X saw the occurrence. X informed the offence to Y and Z. Y lodged a report to the police incorporating the statement of X. Y was declared hostile at the time of trial. So the court held the statement of X to Y and Z and extracted in the report to the police cannot be treated as res gestae to sustain the conviction. So that was discussed in Dharawat Kishan versus State. Now, res means things and gestae means done. So res gestae is a Latin expression and means things done. Res gestae means things said and done in the course of a transaction. Every statement or act which throws light on the nature of the transaction should be received as evidence. For example, 1. The fact in issue is whether A committed the murder of B by beating him. B at the time of beating cried loudly, "Don't kill me." A at that time said, "I will kill you." A bystander then said, "Don't kill him." All the statements made by A, B and C, that is, "Don't kill me," "I will kill you," "Don't kill him," all these statements are relevant facts and admissible in evidence. A person who has heard these statements can give evidence in court, though are not fact in issue. These statements are so connected with the facts in issue as to form the part of the same transaction. Now another example. The fact in issue whether B owes money to A under a promissory note. B at the time of execution of the promissory note said, "I have never borrowed money. It is the first time in my lifetime. I am badly in need of money. My daughter's marriage is on the next month." The statement of B is relevant under section 6 of the Evidence Act, that is doctrine of res gestae, though not a fact in issue. A person who heard the statement of B can give evidence in court. Another example, A sues B for libel contained in a letter forming a part of a correspondence. Letters between the parties relating to the subject out of which the libel arose are relevant, though it may not contain libel. Now, the next is statement by deceased person. So, that is a dying declaration that is discussed under section 32. A dying declaration is called letterum mortem. Letterum mortem. Letterm. Letterum mortem. M-O-R-T-E-M. Letterum mortem. So, meaning words uttered before death. It may be in verbal or in writing or even by gestures if the dying person is unable to speak. When a statement is made by any dying person as to the cause of his death or facts constituted in the offense or reasons for his death, such statement is called a dying declaration. The statement may be made before the cause of the death or the circumstances which resulted in the death. The declaration can as well be about the reason why the killing is anticipated. Statement written or verbal made by a person who is dead or who cannot be found or who has become incapable of giving evidence or whose attendance cannot be procured without delay are relevant in the following cases. The first, when it relates to the cause of death. Second, when it is made in the course of business. Third, when it is against the interest of the maker. Fourth, gives opinion as to public right or custom or matters of general interest. Fifth, when it relates to existence of relationship. And sixth, when it is made in a will or deed relating to the family affairs. Now, difference between the English and Indian law with respect to dying declaration. Dying declaration is discussed in section 32 of Indian Evidence Act 1872. Now, the first difference is that Under English law, dying declaration is admissible in criminal cases only. In the Indian law, dying declaration is admissible both in civil and criminal cases. The second difference is that under the English law, dying declaration is admissible in criminal cases in relation to the single instance of homicide, that is, death where the circumstance of death is the subject of dying declaration. In the Indian law, dying declaration is relevant irrespective of the nature of the proceeding, if the cause of death of the deponent comes in question. Now, dying declaration is admissible if the following conditions are satisfied. That is, the following conditions must be fulfilled in order to admit a statement. The first one, the person making the statement must have died. The second, the statement should be as to the cause of his death or as to the circumstances resulting in his death. The third, the cause of death must be in question. The fourth, the person making the statement must be in a sound position to make the statement. And the fifth, the statement must be complete and declarant must be competent. Now, once again, with respect to English law and Indian law. In English law, the declarant should have been in actual danger of the death at that time. This is not necessary in Indian law. Once again, with respect to English law, the declarant should have been in actual danger of death at that time, and that is not necessary in Indian law. Now the second one, the declarant should have been aware of the danger and abandoned all hope of recovery. That is with respect to English law, and this is not necessary in Indian law. Now with respect to English law, the declarant should have died, and that is also applicable in Indian law. Now, we have two very important case laws here. That is, one is Maksudan versus State of UP 1983 and Pakkala Narayana Swamy versus Emperor in 1939. Two important case laws with respect to dying declaration, that is Maksudan versus State of UP 1983 and Pakkala Narayana Swamy versus Emperor in 1939. So, Maksudan versus State of UP. That is 1983 case. Here the court held dying declaration is a sacred statement given by a person on deathbed. Much value is to be attached to the dying declaration, especially when it is corroborated by other evidence. The dying declaration must have some proximate relation to the actual occurrence. Dying declaration is admissible if recorded by a competent magistrate in a proper manner. There is, however, no particular format of a dying declaration. The court may take into account the whole of the dying declaration. The court cannot accept a part and reject a part of the dying declaration. So that was held in Maksudan versus State of UP 1983 case, that dying declaration is a sacred statement given by a person on deathbed. Much value is to be attached to the dying declaration, especially when it is corroborated by other evidences. Now, the dying declaration must have some proximate relation to the actual occurrence. Dying declaration is admissible if recorded by competent magistrate in a proper manner. There is, however, no particular format of a dying declaration. The court may take into account the whole of the dying declaration. The court cannot accept a part and reject a part of the dying declaration. So that was held in Maksudan versus State of UP. And another important case law with respect to dying declaration is Pakkala Narayana Swamy versus Emperor 1939. Pakkala Narayana Swamy versus Emperor 1939. The peon was in secret love with the daughter of a divan, but the divan got his daughter married to the accused. Now, Pakkala Narayana Swamy accused Pakkala Narayana Swamy. The couple lived elsewhere at Berhampur. The love affair, however, continued and there was an exchange of letters. Pakkala Narayana Swamy got into financial difficulties. His wife borrowed money from the peon totaling of 3,000 rupees. The peon received a letter asking him to come to Berhampur to collect the amount. The peon left for Berhampur, never to return. His body was found in a trunk in a train at Puri railway station. The widow, on enquiry, stated that her husband had left for Berhampur to collect the amount. The accused Pakkala Narayana Swamy admitted that he had seen the peon sleeping in the outhouse the previous night. The investigation revealed that the accused had brought a steel trunk to the house and took it to the railway station. So the court held the Privy Council convicted the accused on the basis of the dying declaration. The statement by the deceased to his wife, I am going to Berhampur to get back the money from the accused, was made admissible in evidence. It was admissible under section 32 as a circumstance of the transaction which resulted in the death of the deceased. So that is with Pakala Narayana Swamy versus Emperor, and that is in 1939. So this is the end of this section, that is rule against hearsay evidence. So we discussed about what is hearsay evidence and what are its exceptions. This section is mainly related to the exceptions, that mainly deals with the dying declaration, two very important case laws in dying declaration, then res gestae principle. So that is with it, and the case laws discussed here, the relevant section for res gestae is section 6 and dying declaration is section 32, and the relevant case laws discussed here is Pollachin versus State of Kerala, R versus Foster, R versus Christie, and Nasruddin versus Emperor. Then we have Dharawat Kishan versus State, then Maksudan versus State of UP, Pakala Narayana Swamy versus Emperor. So these are the cases, out of which Maksudan versus State of UP and Pakala Narayana Swamy versus Emperor is with respect to dying declaration. Dharawat Kishan versus State is with respect to res gestae versus narration, and Pollachin versus State of Kerala, R versus Foster, R versus Christie, Nasruddin versus Emperor is related to res gestae principle. So that is the end of this session. Thank you for listening. Like, comment and subscribe. Click the bell button and stay tuned for the next update or the next upload, in which we will be covering about the rest of the topic, and the next topic is on admissibility of confessions. So thank you. See you again in the next session. Bye.